Today we're going to be talking about updates to some of the state OSH plans and some of the unique regulations that they have, unique practices and appeals processes, just to give you all a feel for how things may differ from state to state, especially if you're a nationwide employer or a larger employer that operates in several states, states with state plans. It's important to understand the unique aspects of those programs. So I'm Dan Deacon. I'm a partner based out of our Washington, D.C. office. I work a lot in the state plans around the D.C. area, Maryland, Virginia, North Carolina, in addition to many of the state plans out on the West Coast. I'm also joined by my colleagues, Megan Shaked, our California practice lead and partner out in San Francisco, and Valerie Butera, senior counsel based in our Detroit office. So we're going to dive in and give you a brief overview of the agenda today. We're going to give you a highlight of the federal OSHA program versus state plans and how those interact. We're going to go over each one, not every single one, but a number of different state plans and provide some of the updates and how those compare, some of the unique aspects, like I said, by way of the regulations and requirements that they have, but also the appeals processes. And then we're going to conclude with some best practices where you have employees working in multiple states and employees or workplaces, I should say, that may be subject to these state plans. So starting out with the overview of FedOSHA versus state plan states. This is just the general framework, right? Federal OSHA regulates private employers, but not state and local government employers. State plans, they can regulate state and local government employers and or private employers. There's a process in place in which state plans need to apply and be approved for that state plan status under the OSH Act. And as of today, we have 22 state plans throughout the country. So almost half of the jurisdictions operate some form of a state plan, whether that's regulating just state and local government employers or also private employers, a combination of both. FedOSHA requires all employers to post the OSHA job safety and health. It's the law poster. There may be some unique state plan posters that you should be aware of. On the reporting side of things, OSHA, federal OSHA that is, requires employers to report work-related fatalities within 8 hours of finding out about them and inpatient hospitalizations, amputations, or loss of an eye within 24 hours of learning about it. There's many states out there where those timing requirements are different, what you have to report, and the definitions of those terms may differ slightly from what you may be used to in other jurisdictions, in FedOSHA jurisdictions or other state plans for that matter. So that is one unique aspect that you should be keenly aware of. Every regulated establishment in FedOSHA jurisdictions is subject to inspection by OSHA, safety and health compliance officers. On the state plan side of things, those are state officials conducting inspections and issuing citations, and you go through that state program, whatever the appeals process that they have in place there. In some, there may be an administrative body that handles it. In others, for example, in Virginia, that is operated through the circuit court system. So there's, again, different appeals processes and how that transfers and makes its way up through the system. On the penalty side of things, federal OSHA, they assess civil monetary penalties, and those are adjusted annually for inflation. In a lot of state plans, you'll see base penalties that may be a little lower. They're not subject to the annual adjustment for inflation. And there's some dispute, especially right now in South Carolina, over their penalty structure. For those of you in Oregon, you may be aware of just recently, within the last year and a half, 2 years or so, the update to Oregon's penalty structure where for repeat willful citations that caused or contributed to a fatality, they can be upwards of $250,000 plus. So there's a range of different penalty amounts that you may see in various state plan states that are much, much different from the federal OSHA system. So moving on to the next slide, we're going to kind of start the road trip here. This is just an overview of the states that are in Fed OSHA jurisdiction, those in the light blue, and those in the darker blue are those state plan, state approved state plans. So as we move on to the following slide, we're going to get into the state plan comparisons and just starting out kind of the basic groundwork here and things that you want to keep an eye out for and be thinking about if you operate in a state plan. First being the procedural quirks. Are there any unique aspects to contesting the citation? In the federal OSHA context, you have 15 working days from receipt of that citation to file an appeal. In many state plans, that is different. For example, Minnesota, it's 20 calendar days from when you receive the citation. Same in Hawaii, there's the calendar day count as opposed to the working day count. So there's some procedural quirks as it relates to ensuring that you file your appeal timely and that notice of contest, how you do it, what needs to be included in that appeal. So you want to take a close look at each one of these state plan regulations for what is required to formalize your appeal and make sure that it's perfected in a timely manner. Unique regulations. There's some state plans out there that follow FedOSHA regulations verbatim, right? And they incorporate them by reference. There may be some unique rules that are added in certain state plans, and then you have some that pass their entire book of regulations, California, Washington, for example, that have their own set of safety and health regulations that are passed independent of FedOSHA's. Of course, they have to be at least as effective, but you won't see as much of that, incorporation by reference, all of these sections from the federal OSHA regulations. Fourth, particular enforcement priorities. You want to check your state plan for specific enforcement programs, that targeted enforcement programs and priorities that they may emphasize in that region. And then finally, different interpretations and enforcement of the rules. Of course, the state plans have to be at least as effective as FedOSHA. They can be more stringent than FedOSHA though, right? So there may be different interpretation of certain rules, how they apply them to you as an employer within that state, in that jurisdiction, and how they enforce it. So it's not the same across the board, right? And the idea here and the message we're sending is it's important to really pay attention if you're operating in a state plan, how those agencies are operating and enforcing the rules as they apply to you in the workplace. So with that, I'm going to turn it over to Val, and she's going to kick us off with an overview of some of the state plans, beginning with Minnesota.
Thank you, Dan. So I'm going to start out in the Midwest. First stop is Minnesota. But probably the biggest thing that's different about Minnesota is this AWARE program. And that is employers that have certain NAICS codes, those that Minnesota has sort of deemed more high hazard, where there's a higher incidence rate or severity rate above the Minnesota average, are required to participate and to create this program in their work sites. And the list of targeted industries is revised every 5 years. And what this is a written program that includes a great deal of information, including, how your managers and your supervisors and employees are going to be responsible for implementing it, methods used to sort of identify and control hazards and conditions in the workplace, how you're going to go about investigating accidents and what kind of corrections will be put in place, and how safe work practices will be enforced. Covered employers also have to conduct and document a review of the workplace accident and injury reduction program at least annually, and document how the procedures included in the program are being met. Minnesota also has record keeping for everybody. There's not an exception in record keeping in Minnesota. All businesses, regardless of size or perceived level of risk, must do record keeping. There's interesting and unique indoor temperature requirements. These are standards that provide, sort of depending on the level of exertion and how hard the work is, how warm or cold the indoor environment can be. There are safety committee requirements. This is if you have either a lost workday case incident rate in the top 10% of all rates for employers in the same industry, or a workers' compensation premium classification rate in the top 25% of premium rates for all classes, you are required to have a safety committee. Minnesota OSHA now has an ergonomic standard that applies to employers who operate warehouses and distribution centers in the state. The rule applies to all warehouse distribution center employers with 100 or more employees. Under the standard, covered employers have to develop and implement a written ergonomics program that details their plan to minimize the risk of employees developing or aggravating musculoskeletal disorders. The written program needs to address a series of elements, all of which are required by the standard, including completion of an ergonomics assessment, training, early reporting procedures, employee input and involvement, continuous improvement, and program evaluations.
One quick thing here, I want to emphasize on this ergonomics rule. This is pretty unique. It's one of the only state plans that currently has one of these, and it's a big priority in Minnesota. There's been a lot of emphasis on this and enforcement of this rule in particular in warehouses. And what we're seeing out of Minnesota is a significant uptick in appeals based on enforcement of this rule, which is actually creating a backlog in the system, where once the case elevates to the Attorney General's office, you might be waiting a year plus before it's even docketed and moved through the system. So that is a big enforcement priority in Minnesota right now, and something that if you operate there, take a close look at it.
And that is a good sort of entree to talking about the appeals process in Minnesota. The appeals there, your first appeal has to be notarized. And your informal conference, you can expect not just a supervisor to be there, but also an AHE. During fiscal year 2023, the Minnesota State Plan completed legislative changes, which now brings their penalties in line with federal OSHA's penalties. And there's plenty of weird stuff to talk about in my home state of Michigan. First in my mind is that unlike any other state in the union, in Michigan, all OSHA interviews are private, even interviews of supervisory employees. Historically, OSHA permitted employees, supervisory or otherwise, to bring someone with them into interviews, typically union representatives, supervisors, and sometimes council or management representatives. In fact, since of course supervisor knowledge is imputed to the company counsel and other managerial reps were typically permitted to sit in on interviews of supervisory employees. But over the past few years, OSHA has taken this stance, and they stand by it firmly, that only OSHA personnel can be present during any OSHA interview. The policy has been around since 2022, but surprisingly, it sort of took a while to make it to court. It wasn't really challenged until the last year or two. But now there are several cases at the trial court level and one pending at the Court of Appeals challenging this policy. So we're hoping to see some relief on this soon. OSHA's penalty structure lags behind federal OSHA's, which that's caused a lot of sort of chaos. And the legislature here tried to fix that recently, but it's sort of stalled at the moment. It's with the Senate Labor Committee and hasn't had any movement for several months. OSHA adopts most federal OSHA standards, but there are plenty of standards that are unique to the state, so that's something to keep an eye on. There's sort of too many even to, there's not any one that's particularly more or less uniquely regulated than others. So you kind of need to, if you're in Michigan, be familiar, have a general familiarity with all the OSHA standards. In addition to federal OSHA standards, just have some sort of a general awareness of the unique things about it. The appeals process is sort of different in Michigan too. The first appeal, honestly, is usually just flat out denied. You send in your appeal letter and very quickly we'll hear back from OSHA that it is denied no matter what the circumstances. Then you have the second appeal that goes to the appeals division. With the appeals division, you can have a pre-hearing conference, which is akin to the informal conference that you would have with federal OSHA. Honestly, though, those are usually a sort of an uphill battle as well. It's hard to get a really satisfactory settlement there. So a lot of the time, if you're trying to really settle the case, you have to keep pushing it forward. And it is possible, certainly, to settle a case in Michigan, but just know that it's a long process usually, and there's a lot of back and forth. Next up is Indiana. IOSHA adopts all of federal OSHA safety and health standards and federal program changes with some differences when they're allowed. Interestingly, Indiana state law doesn't allow IOSHA to have any regulations that are stricter than federal OSHA standards. There's several active state emphasis programs in Indiana. The latest and greatest is the Hoosier High Hazard Manufacturing Emphasis Program, and that focuses on non-fatal injuries and illnesses in the manufacturing sector. Each year, the plan there is to target a list that's going to be generated of the top 5 manufacturing industry NAICS codes groups with the highest injury and illness rates that year. This year's list is mostly vehicle production related and it includes foundries. There's also several longstanding local ongoing emphasis programs in construction and general industry fall hazards, building renovation, rehab, and demolition, and residential construction projects. Appealing citations is a little different in Indiana too. For example, post-informal conference appeals involve formal discovery processes, and penalties must be paid before settlement agreements are signed. IOSHA is one of the states that has not adopted the federal OSHA penalty structure. Legislature has attempted to fix this, but so far the attempts have been unsuccessful.
Thank you, Val. So I'm going to cover Maryland and Virginia here and give a brief update on the news coming out of each one of those states. On the Maryland side, there's not a whole lot to talk about as of by way of 2025 updates. But one of the big things that happened in 2024 was the passing of a new heat stress rule for both indoor and outdoor, setting the heat index threshold of 80 degrees. This was the first heat stress rule to be implemented and passed on the East Coast. It mirrors a lot of what you see in some of the West Coast states that have passed these and had those in place for quite some time. Provisions for water, shade, rest, acclimatization, high heat procedures, and how you handle emergencies and responding to heat illness events. Generally, Maryland follows FED-OSHA rules, but there are a couple specific rules for crane operators and rigging, tree care and removal, and fall protection and steel erection. The contest process is very similar to FED-OSHA's in that you have 15 working days to file that notice of contest with the commissioner. And any hearing is done before a hearing examiner appointed by the Commissioner of Labor, and any appeals from that decision would go to Maryland Circuit Court. On the Virginia side, there are some updates here, but first we'll talk about just generally how the system is set up. Most of the rules largely mirror FED-OSHA rules, but they do have some specific requirements for the telecommunications industry, tree trimming, sanitation, steel erection. And one notable thing that was passed within the last year was workplace violence rule as it relates to medical care facilities. This isn't something that is under the OSH regulations, rather the healthcare regulations. Nonetheless, it is something that kind of spills over into the workplace safety side of things. So for those of you that have medical care facilities in Virginia, please be aware of this bill, Senate Bill 1260, and the requirements as it relates to medical care facilities and workplace violence. The appeals process, you file your notice of contest within 15 working days, and the informal conference is held with the district or regional safety or health directors and managers. If the case can't be resolved there, the case is sent to Richmond to the Attorney General's office, and they're required to file a complaint in local circuit court in the jurisdiction where the incident occurred or where your workplace is, where the workplace was. And that's heard by an elected or circuit court judge. We don't see many cases reaching that stage, the circuit court level. you'll find a lot of times the case file stays with the local VOSH office, where you engage in settlement discussions for could be 2+ years in some cases. We don't see, again, a lot of enforcement at the circuit court level. Not to say that it doesn't happen, but they tend to keep those case files internally at the agency. Oh, and one other thing in Virginia, this is over the past week and a half or so, they did pass the legislature, that is a bill to implement a heat stress standard, directing VOSH to promulgate a rule by May 2027. So this is something that's coming from the legislature. We haven't seen a proposed rule or anything like that, but this was something that was just introduced, passed, and is coming uh, down the pipeline in the next couple of years.
Tennessee is another one of the states that's not yet adopted the federal OSHA penalty structure. It's got a few unique standards, including no smoking in the workplace, special firefighter protections. They have enhanced sharps injury protection, annual training for HAZCOM, which is not required for federal HAZCOM. Usually it's refresher training because you're introducing a new chemical or something along those lines. You don't have to have that annual training, but you do in Tennessee. And enhanced toxic chemical rules. Tennessee generally has lower permissible exposure limits than federal OSHA does. Tennessee has three local emphasis programs that are active in carbon monoxide, noise, and dental offices. The dental office program focuses primarily on bloodborne pathogens. Tennessee requires employees that it deems high risk also to establish a safety committee. North Carolina tends to adopt federal OSHA standards, but it has some unique standards too. There's notable differences, for example, in its HAZWOPER rule and bloodborne pathogens rule. They have a specific rule for field sanitation and agriculture. Although the state doesn't seem to be pursuing a heat stress standard, they have recently been making a push to inform employees that they can't be forced to work in dangerous or inclement weather. And they're really advertising quite a lot and encouraging employees reporting employers who are requiring them to work when conditions are unsafe during floods, snow, hurricanes, or when road conditions are hazardous. North Carolina's local emphasis programs are called special emphasis programs or SEPs. The current active SEPs in North Carolina are in amputations, construction generally, food manufacturing, health hazards, that's silica, lead, chromium, beryllium, lodging, long-term care, warehousing and storage, and a very, very new one, a struck by SEP that's going to focus on preventing struck by injuries and fatalities in general industry and construction. And North Carolina penalties keep pace with federal OSHA penalties. Utah OSHA adopts most federal standards and it supplements them with additional requirements. In Utah, I should note, is another state that has many additional requirements. So there's a lot to kind of wrap your mind around there. Businesses there that are successful in their safety management and achieve sharp recognition are exempt from UOSH inspections during the entire time they have that recognition. Informal conferences and appeals are a little bit different there. Employers in Utah have 30 days to submit a written notification to the adjudication division when they want to contest citations. Utah has local emphasis programs right now in construction, amputations, silica, public sector work, combustible dust, falls in general industry, and warehousing and distribution center operations. UOSH penalties are nominally lower than federal OSHA penalties, but they're really close and they're adjusted annually for inflation. So they pretty well keep pace with what federal OSHA has going on in terms of penalties.
Thanks, Valerie. So moving closer to the West Coast, we have Arizona. Arizona is not a state that we covered in this webinar last time. We did a state OSH plan review. Things are usually quiet in Arizona, but we did want to provide an update this year because we have seen an uptick in activity out of this state. Just for some background, back in 2022, there was a proposal to strip Arizona of its state plan status. Federal OSHA was considering resuming jurisdiction over Arizona. That proposal was withdrawn in 2023. So there's definitely some pressure on the state to engage in its enforcement activities. In 2024, their goal was conduct inspections. 1,175 inspections was their goal number, and they performed 616 inspections. So though we anecdotally have seen more efforts there, they are still, at least in 2024, the last report we have, we're below that. So, that number may change, that percentage may change over time with a little bit more pressure from federal OSHA. Some just unique aspects. Again, we know which regulations the state adopts from federal, and then which ones they have unique ones. Here, their reporting requirements it is a shorter period, the 8 hours for fatalities. And then inpatient hospitalization, amputation, or loss of eye within 24 hours. There are some nuance to the Arizona requirements. So just like Dan mentioned in the beginning of the webinar, reporting is often one that you just have to understand what each state OSH plan requires and kind of keep track of that, of the nuance between them, because there are little things that can differ from state to state. Given its location in our country, heat stress, as it is many other places, as you can imagine, is a high priority item. They do have a state emphasis program, and there was an order from the governor. So there's a workplace heat safety task force in place, and they're tasked with recommending heat guidelines for employers. That's still in the process, but some deadlines have hit recently. And so the recommendations were due, and those are now being reviewed. So heat illness is definitely something to be on the lookout for in Arizona, to understand what specific guidelines the state is going to recommend. And then, like I mentioned, Arizona enforces federal OSHA standards, and though it does have some unique standards of its own. And then moving to Nevada. Nevada, just give you a sense of comparison for Arizona. In 2024, Nevada conducted a little over 1,200 inspections, 85 over their goal of 1,200. And of that 1,285 inspections, 416 of them were conducted through health, and 831 were safety. Those ones were all in the private sector, and then they had a couple of dozen that were in state and local workplaces. So that's a very active state. We see Nevada being very active in certain industries. They're following their emphasis programs and prioritizing their on-site inspections accordingly. We also see very thorough inspections. So understanding that Nevada is taking their responsibilities very seriously, being very thorough, asking follow-up questions, and issuing citations at penalty amounts that are sometimes surprising for employers. So a couple of other things to highlight here. For heat illness, topic you will continue to hear over the next 30 minutes. In 2024, Nevada adopted a regulation addressing heat hazards in indoor and outdoor workplaces. So this is relatively new, and we have seen enforcement efforts under the new rule, which is, of course, a helpful educational experience to be able to interface with the agency and understand how they're interpreting those requirements now that those are in place. We spoke last time. We talked about the Nevada State OSH plan, that the heat illness rule is actually quite reasonable and allows for a lot of practical realities of employers. For example, it acknowledges that a workplace may not be covered because it may have functioning air conditioning. And so it has a specific allowance for what happens when that air conditioning is not functional for whatever reason. Um, but again, to my point about Nevada being very thorough in their inspections, they're really holding employers to account for their heat illness program. And it's really not just a check the box exercise. We have a heat illness program, let's move on. There does seem to be some real emphasis on making sure that that program is working as intended and effective in addressing the risks of heat in the workplace. Nevada enforces federal OSHA standards again and has adopted some unique standards of their own. There's a whole list for reference. So sometimes you see citations issue under their own Nevada rules, and sometimes they're referencing the federal regulations. Nevada has some unique requirements when it comes to workplace safety programs and safety committees. They have some very specific requirements for written programs, and very, very specific requirements for safety committees. And these are generally triggered by employer size once you reach a certain threshold. But it is something to be aware since it's a little bit of a unique requirement. Nevada has, so their regulations live in a couple of different places in their statutory scheme. But they also have a Nevada operations manual, which provides guidance for their enforcement program. And when we talk about making sure that employers have a good understanding of the state plan states, we understand that the reality may be you can't know everything ahead of time, but it is helpful to know what resources might be out there to become more familiar and kind of dig deeper on your understanding. Or this is something obviously that you can do through counsel to make sure you do have the information that is readily available publicly to understand where at least the agency is coming from on a given inspection, because that manual does provide guidance for them in conducting their enforcement program. So can be a helpful resource for employers as well. To the point about knowing how the appeal process itself works, Nevada is one of the states that has a two-step program, a two-step appeal process. So citations will issue, employers have a right to submit a notice of contest, and then a summons and complaint will issue, and employers have an ability to answer, to file an answer, and then you're in litigation dealing with division counsel. And then another thing, always to check the emphasis programs. Nevada in particular is they take very seriously their emphasis programs in targeted high hazard industries. And those, again, like I said, tend to be very thorough. So good to know if your workplace falls into any of those emphasis programs so you can prepare accordingly. And with that, Dan's going to take us to the West Coast.
Yes, thanks, Megan. We're gonna end with the last three state plans that we're going to be covering in the webinar today. The West Coast state plans, so Washington, Oregon, and California, probably the most detailed and unique state plans that are out there. And a lot of you have probably encountered dealing with one of these agencies, and it is Much different than probably what you experience elsewhere, certainly in the OSHA context, but even other state plans. So starting with Washington, the Division of Occupational Safety and Health was founded in 1973, just 2 years after Congress created OSHA, right? They have a long-standing history of being focused on safety and health, dating back to their original state constitution in 1889, where it was directed, the legislature was directed to pass laws focused on factories and mines. So they have a long history of focusing on these issues, and it wasn't a surprise that they wanted to be their own state plan, and perhaps as of today, the most unique one that's out there. 2% of the nation's workforce. That's all that Washington has. They conduct over 5,000 inspections a year. When we put that into perspective, just about, the total number that OSHA is doing on an annual basis, somewhere, in the low 30,000, we have 5,000 inspections just out of this small state with 2% of the nation's workforce. Other comparative notes, right? It's 1/3 of the working population of California, and they're performing almost the same number of inspections. So very, very high on enforcement here. They have a significant budget that's funded by the workers' compensation system that's run by the state. As far as appeals go, it's a two-step appeal process, and we'll talk about that in a little more depth in a couple slides from now. But all appeals are heard before the Washington Board of Industrial Insurance Appeals, and any subsequent appeal after that goes to state superior courts. Some unique DLI rules, interpretations, and directives. We're going to start with the Accident Prevention Program. For those of you that are familiar with California's I2P2 program, it's very similar. It's supposed to be a comprehensive safety and health program that addresses hazards employees may face in the workplace. We see this in a lot of inspections. That's one of the first requests. Give us your accident prevention program, similar to what you see in California, right? And it is one of the most frequently cited standards in Washington. So that is something that you want to take a look at if you don't have a safety and health program that aligns with all the requirements of Washington's accident prevention program. You might need to make some tweaks and get that sorted out because they ask for it in every single inspection. A safety committee and safety meeting requirements, depending on the threshold of employees that you have on a certain shift. If you have more than 11 employees on a shift, you have to have a safety committee at that location. There's unique reporting requirements in terms of the timing in which you're obligated to report, unique fall protection requirements. They have indoor or outdoor heat illness program, wildfire smoke. This is something that is supposed to be addressed in your accident prevention program as well. And it's certainly on the eastern side of the state, something that we see requests for in every single inspection as well. They have initiatives for protecting temporary workers that is unique to the state, safety standards for quotas in warehouse distribution centers. Washington's the only state that has a specific hazardous drug program and standard. And they have a unique general duty clause-esque type regulation. It's called the Safe Workplace rules. And if there isn't a specific regulation that applies, you might find yourself with a citation under one of these safe workplace rules. Bloodborne pathogens has some unique modifications to it as well. And stay of abatement. This is a big one in Washington. It's one of the only states where abatement is not stayed pending the resolution of an appeal. You have to specifically ask for a stay of abatement where it's litigated before the board, and a decision may be made prior to the resolution of the citations and the disposition of those. So you may be forced, in many cases, to abate the hazard prior to resolving the case under appeal. The Severe Violator Enforcement Program in Washington, the criteria in which you may find yourself in the SVEP program there is much less stringent than what is in OSHA's SVEP program and what you might find in other states. And then finally, the last one here, it's STUT violations. This is general contractor liability. They apply this more so as a strict liability. So if you're a general contractor in Washington, a lot of times any violation committed by a subcontractor on your work site, you are going to receive the exact same citation. We've seen this time and time again, and they're very inflexible with it. This is based on case law from tort, and the way that the agency enforces it is essentially strict liability, and very, very frustrating citations. So moving on to the next slide, this is just an overview of the top 10 violations in general industry and construction, an overview of where you can kind of identify some of the top things that Washington DLI is enforcing and priorities for them, things that we see often, right? The accident prevention program, what I mentioned, both in construction and general industry, fall protection, HAZCOM, the safety committees and safety meetings. The accident prevention program and safety committee or safety meeting documents are two things that are included in every single request for production of documents at the beginning of an inspection. So those are two things that they're automatically looking at every single time. Portable ladder use and things like first aid as well. So moving on to how does the appeals process work in Washington? It's a two-step appeal process. The first appeal needs to be filed with the agency with DLI within 15 working days of receipt. They actually have specific requirements outlined in the regulations about what needs to be included in that, as far as the address, contact information, certification of unions, and an outline of the reasons why you're appealing each citation and the basis of that appeal. So DLI can do one of two things when you file that first step appeal. They can either reassume jurisdiction over the appeal, where you have a reassumption hearing with a hearing officer from the department, or they send the appeal directly to the Board of Industrial Insurance Appeals for what is known as a direct appeal. If the department does reassume jurisdiction and you have that first step appeal hearing, at the conclusion of that, the reassumption hearing officer is going to issue what's known as a corrective notice of redetermination. And that corrective notice of redetermination, or CNR, basically modifies a citation in some cases, rare cases, right? You might get something withdrawn, or they affirm the citations. So from there, you can file a second appeal to the Washington Board of Industrial Insurance Appeals. And that's going to be on the next slide, the second step appeal. So once you receive that corrective notice of redetermination, you have 15 days from receipt of that to file an appeal with the board. And it's substantially similar to the appeal that you filed with the department at the first stage. There's some additional tweaks that need to be made to align with the board rules, but substantively, it's largely the same. The appeal is going to be docketed with the board, and then there's a mandatory mediation that's scheduled with a mediation judge and the Attorney General's office, an attorney assigned from the Attorney General's office. And they usually give you a couple months, a few months to try and sort that out. And in some cases, they can extend it a little longer if you need more time. If you're unsuccessful or we can't find a resolution in mediation, that's when the case will be assigned to the hearing judge and a scheduling order will be issued. So the cases in Washington tend to take a long time. They definitely are much longer than what you'd see in other jurisdictions, certainly in OSHA jurisdictions where, a case is docketed with the Occupational Safety and Health Review Commission pretty much right after you file that notice of contest. There may be a certain window where you can get an extension for a little bit of time, but the litigation process happens pretty quickly. In Washington, it takes a little bit of time to get through the system, and it's longer. Any appeal from the board decision would be made to Washington Superior Court in that jurisdiction where the employer is located. So next slide here is about the stay of abatement request, and I touched this on a slide or a couple slides ago. Unlike almost every other jurisdiction in the nation, abatement is not stayed pending the outcome of an appeal. In your initial appeal, that first step appeal that you make to the department, you need to include a specific request for a stay of abatement. So this is really a note to make sure you're looking at the citation, the abatement deadline that they have on there, and whether abatement is due. and have a serious conversation about how you are going to address that, because you are going to have to address it probably sooner than you would like, and certainly sooner than you would in other jurisdictions, even if you are filing the appeal. Um, it is pretty tough to get a stay of abatement even before the board. It is a substantial burden for you as an employer to show why abatement should be stayed. So that's just an anecdote that be prepared. Oftentimes, even if you have or you feel that you have really good arguments for why abatement should be stayed, it is very, very difficult to get through that process before the board. Even if you file the second appeal, there's going to be a decision on whether abatement was stayed or not. And you don't want to find yourself in a situation months down the line when Washington DLI comes in for a follow-up inspection to see if abatement has been completed. Because even if your appeal is still pending, they'll issue failure to abate citations. The next slide, we're just going to go over some quick updates and anecdotes about Washington DLI over fiscal year 2024. They did 5,884 inspections. As I mentioned, just over over 2% of the nation's workforce, just shy of 3.5 million. But what we see from the FAME reports and everything that we get data-wise, it's almost 3 times as much as enforcement activity as the national average. So, like I said, they have a significant budget, well-staffed, and they are out there enforcing very, very significantly and heavily. On average, per inspection, you're going to see 3 or more violations, about 1.61 serious violations per inspection. So if they show up, odds are you're likely to go receive some type of citation, some type of violation, and the two-step appeal process is your recourse there. So the next slide is just some proposed and active rulemaking they have going on. The ergonomics being the big one, and we're going to talk about that in a slide here. We talked about the ergonomics rule in Minnesota and how that applies to warehouse distribution centers and healthcare facilities. It's usually limited there to much larger employers. In Washington, it's going to be limited, and they're phasing in certain industries, and we'll talk about that in a second here. But there's been updates to the HAZCOM standard, proposed rule to update the lead standard, longshore and waterfront operations, tower crane permits, adoption of the EPA rural worker protection standard, that's an agriculture context, and just the ability for them to enforce that EPA rule essentially. They're in the process of adopting the OSHA worker walk-around rule, and finally, workplace violence in healthcare. So things to keep an eye out for if those apply to you, you're in one of those industries in Washington. So the one I really want to focus on here is the ergonomics rulemaking. This was something that came down from the legislature in 2023, repealing the prohibition on rulemaking addressing MSDs, and allowing the agency to develop an ergonomics rule. Nothing can be finalized before July 1st, 2026. That's not too far away, right? Less than 4 months. And they're in the process of promulgating this as it relates to the airline industry and carriers there. So the rule, like I said, it's going to be phased in based on NAICS codes and starting with one industry at a time. Right now they have 5 earmarked, the 5 that you see on the screen here. And that's based on risk classes and where they've seen the most MSD injuries in those industries. So they're focusing the rulemaking on those to begin with, and it may be coming down the pike in your industry sooner or later. So the general framework for the rule on the next slide here is basically what we're going to see, right? The scope, who's going to be covered, risk identification, how are we going to screen to identify MSD risks in the workplace, the risk and hazard assessment that goes into it, evaluating the MSD risks, how we're going to reduce that and prioritize efforts to address them. what engineering and administrative controls can be implemented in place to mitigate MSD risks, uh, annual evaluation of its effectiveness, making sure that our employees are involved in the process, identifying hazards and potential solutions, and of course, training and record keeping requirements. So moving on now to Oregon, and then we're going to turn it back over to Megan to cover California and wrap things up. Oregon is another state plan that has been around for a long time, dating back to almost when OSHA was founded, right? Another state with a long history of safety and health efforts. The Oregon Workers' Compensation Board, the hearings division there, is the group that hears and rules on any appeals from citations. And we're going to talk about some unique aspects of how you perfect your appeal in Oregon in a couple slides here and something that you should be aware of. But the next slide, we're just going to talk a little bit about some unique rules and directives. Oregon's another state that has unique safety committee and meeting requirements. Another state with heat illness prevention and wildfire smoke requirements and rules. Specific rules on the lockout tagout side of things about use of individual locks. And then kind of a catch-all rules for all workplaces rule, similar to what I was talking about in Washington with that general duty-esque type rule, but a little even broader. It talks about proper instruction and supervision, safe operation of machineries and tools. It can be applied very broadly, right? Mandatory investigation of lost time injuries, and making sure inspections are done of the workplace by qualified persons. Stay of abatement. So a little different from Washington. I mentioned in Washington that all citations, there's no stay of abatement pending an appeal, and there's a specific process that you have to go through before the board to get a stay. In Oregon, there's no stay of abatement for serious violations pending the outcome of an appeal. Other than serious violations are handled differently. But again, another unique state. So make sure that you pay attention to that citation, look at the abatement date, if abatement is due, what it is, and how we're going to handle it. The next slide is top 10 rule violations, somewhat similar to what you see in Washington here. And the slide is just intended to provide you with an overview of what the key priorities and things that the agency finds in a lot of inspections, both from the safety and the health side of things. Now, the big change in Oregon that happened over the past couple of years was an increase to their penalty structure and how that is enforced. This was something that was passed by the legislature, not the agency themselves. And the agency, even folks that we've talked to, are having a hard time wrapping their heads around this and how to enforce it. It was something that was pushed for by organized labor and unions before the legislature. So it was kind of tough. Oregon OSHA's hands were tied and it came down from the legislature. But the big thing here, and we have 3 slides on them, just so you have an idea of what this looks like. The penalties in Oregon can be significantly higher, depending on what type of incident happened. And as I mentioned at the beginning, if there is a willful citation that is deemed to have caused or contributed to a fatality, those penalties can be upwards, and that's per violation of $250,000 or more. So something to keep in mind if you are in Washington. These are penalty structures that were passed by the legislature, and the agency is having to enforce them in that manner, and their hands have been a little bit tied and still working through that process. The final slide here is just on the appeals process. Mentioned something a little bit unique. The first appeal or contest needs to be made within 30 calendar days after receiving the citation. You can do this on Oregon OSHA's website. They have a portal where you can perfect this, or you submit a letter. But if you're doing this online, be sure that you're making sure you're filing an appeal and not just requesting an informal conference. I believe they may have updated this on the website because it used to be pretty confusing, where if you requested an informal conference, that didn't necessarily perfect your appeal. And if you didn't get that appeal box checked within 30 calendar days, they said, too bad, so sad, you didn't get in and on time. It wasn't timely. So just make sure that you are clicking the right buttons and actually perfecting the appeal within the timeline, the 30 calendar day timeline. And there's no harm in appealing this, right? Because once you appeal it, they're going to reach out. An appeal specialist is going to reach out to schedule an informal conference anyway. And if you're not satisfied with the outcome from that appeal specialist at the informal conference stage, you can pursue the appeal before an administrative law judge at the Workers' Compensation Board. So with that, I'm going to turn it over to Megan. I think to cover California, the last slide there on Oregon was just some data points that you can go through about the number of inspections that they do in current rulemaking. Not so much there activity-wise as in others, but I'll turn it over to Megan because I know we're running short on time here.
If you've ever heard me talk about California, you know I can talk about California all day, but I will keep it short. And if anyone wants any additional, has any questions, I'm happy to chat, or certainly you can check out our California Cal OSHA webinar series for more detail. But high overview of California. Dan mentioned that Washington was in the 5,000 range, so California, our great golden state, in 2020, I think these are 2024 numbers. California's enforcement program conducted 6,436 inspections, exceeding their goal of 5,850 inspections. So the agency is incredibly busy. They have been making a huge staffing push over the last few years, so that their offices are fully staffed as much as possible. And they are out there in every way, shape, and form trying to get those inspections in. And so, as you can imagine, the appeal process can be very lengthy because there are a lot of appeals to citations that issue after all of those numerous inspections. Just some reminders about what makes California unique. And again, there are many things that make Cal OSHA unique. We have the Injury and Illness Prevention Program out here, which is the #1 most frequently cited standard, both in general industry and construction. And this is where the agency will expect employers to identify, evaluate, correct hazards in the workplace. And we see a lot of citations and a lot of inspections coming out of that standard. We also have outdoor and indoor heat regulations and a special emphasis program that covers both. So if you have a complaint-driven inspection or an incident-driven inspection that has nothing to do with heat, you can still expect questions from the agency on heat illness prevention and, for that matter, your injury and illness prevention program, because they are required to cover those. We have active rulemaking in a whole slew of topics, but 3 I will emphasize, one being hot off the presses as of Friday afternoon, is workplace violence prevention. This currently lives in the California Labor Code, so there is a current requirement, but they are working on the corollary Cal OSHA regulation. They are also, same thing, working on their own regulation to update the citations on regulation, classification of citation and penalties for 2 new categories known as egregious and enterprise-wide violations. And then Friday, they put out a rulemaking package for the worker walk-around rule to respond to the federal rule and implement a California unique version of that rule. California's reporting requirement is very unique. There's an 8-hour rule. There's also an aspect of it, it's not just work related, but things that occur at the workplace. So this is definitely one to take a really careful look at and understand. Some of the requirements that come out of the reporting rule live in different regulations, and there's a lot of nuance to it. So it's a helpful one to work with counsel on if you have questions. We also wanted to highlight 2 things that are happening that can impact enforcement going forward. One is that there was a state audit by the legislature, and there's been a lot of scrutiny on the thoroughness and the agency's following of its own directives. And so, what this means is that there's a lot of eyes on appeals and any changes made to citations issued. And it is certainly impacting enforcement efforts, but also really appeal strategy and negotiations with the agency and with division counsel. It's having an impact across the board, particularly with citations that are issued at the serious level or the serious accident related level. And then the agency is also going through a revision of their policy and procedures manual, and they've identified certain sections that they're working on. So that's something to keep in mind that their own, we all often say, just like I did with Nevada, their policy and procedure manual provide a lot of insight into their enforcement efforts. So that's something that could be changing over the next little bit. I included some details on enforcement in case you are interested in that. Like I said, they've really been working on it. But I'll take just another minute just to kind of summarize what we spoke about at the beginning. Now that you have a little bit more context with all of the unique aspects of each of our state plan states, and we didn't cover all of them, but it's really important when you're thinking through your safety program and how you can best prepare for inspections in a given state to know for your own industry, what are the top most frequently cited requirements in the state? It's likewise, what is the state's priority when it comes to enforcement, not only in terms of emphasis programs, but also just what are the sorts of issues that they are looking at most and they are prioritizing and they're trying to protect against. Knowing certainly how to respond to an incident, a serious injury or illness, since the response time and exactly what you are obligated to do can differ from jurisdiction to jurisdiction. We have spoken a lot about how to prepare for inspections. This is really important to know what you're going to do if the agency shows up. We offer master classes on preparing for inspections and have done lots of webinar series just like this on preparing for inspections. That's an important way to prepare, particularly in different jurisdictions. And then knowing what to do if you anticipate a citation will issue. Again, because some of those deadlines can be a really quick turnaround, and you need to know exactly what to do in different state plan states. Knowing, what's our deadline going to be? What is the procedural step we have to take? And how is any abatement requests impacted by a given state you're in? And then reviewing, any guidance that might be in there apart from the requirements themselves that live in statute or regulations. What is other guidance that might be out there from the agencies that can give you some helpful insight into how they will prioritize enforcement and how they will conduct inspections? So with that, I'll leave you with just a few reminders about some of our offerings. We have a number of master classes that can do a deep dive particular to your workplaces. And then we have our blogs that we keep updated. We try to keep updated with the most important news that kind of comes out on these subjects. As well as our regular webinar series. We'll include the slides for the webinar series for 2026 in the slides that go out to you all in a couple of days when we finalize them. But we also have a whole webinar library of past webinars that you can review as well. We already have our dates for our California Summit if that's something that is of interest to folks. And we're, like I said, happy to answer any questions you may have. And on behalf of Dan and Valerie and myself, thank you very much for joining.